Article 15 Prohibition of discrimination of ground, religion, race, caste, sex, or place of birth. Instead, a particular aspect of equality guaranteed Article 14 is prohibition against the discrimination contained Article 15 of the Constitution, which runs thus: the state shall not the discriminate against any citizen on the grounds on the religion, race, caste, sex, place, birth, or any them. No citizen shall on ground only the religion, race, caste, sex, place of birth, or any of them be subject any disability, liability, restriction, or condition with regard to access to shop, public restaurant, hotel, and places of public entertainment, or the use of well tanks, bathing ghats, roads, places of public resort maintained wholly or partly out of state fund of dedicated to the use of general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in the article or in clause 2 of article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens is for the scheduled caste and the scheduled tribe. Nothing in the article of the subclause G, clause 1, article 19 shall prevent the state from making any special provision by law for the advancement of any socially educationally backward classes of citizens or for the scheduled caste, scheduled tribes, insofar as the special provision relate to their admission to the educational institution, including private educational institute, whether aided or unaided by the state, whether than the minority educational institute referred to clause 1 of article 30. Article 15 of the Constitution has been amended by the Constitution 103 103rd Amendment Act 2019. The 2019 Amendment Act has added a new clause of 6 to the provide for a special provision for the advancement of economically weaker section of citizen, including special provision relating to their admission of educational institute, including the private educational institute, whether the aided or unaided by the state. Other than the minority educational institute referred in to the clause 1st of article 30, a reservation provided under the newly added clause 6 would be added to the existing reservations subject to a maximum of 10% of total seats of seat category. Clause 6 of article 15 provides as follows: nothing in the article or subclause Z, clause 1 of article 19, clause 2 of article 29 shall prevent the state for making any special provision for the advancement of any economically weaker section of a citizen other than the classes of mentioned class 4 and 5, and any special provision for the advancement of any economically weaker section of the citizen other than the classes mentioned in clauses 4 and 5 in so far as a special provision related to their admission or educational institute, including private educational institute, whether the aided or unaided by the state, whether than the minority educational institute referred in clause 1 of article 30, which is the case of reservation, would be a addition to the existing reservation and subject to maximum of 10% the total seat of each category. Explanation: for the purpose of article and article 16, economically weaker sections shall be such as they notify the state from the time to time on the basis of family income, other indicator of social economic disadvantage. In the scope of article is verified by the provision of clause 1 is the leveled against the state action. The provision of clause 2 is the leveled against the individual as well. Clause 1 says that any act of state, whether the political, civil or otherwise, shall not be discriminate as between the citizen or ground on the religion, race, caste, sex, place of birth, or any of them. The plain meaning of the prohibition is that no person of the particular religion, caste, etc. shall be treated unfavorably by the state when the compared with a person of any other religion or caste merely on the ground of that they belong to a particular religion or a caste. Significance of the word only: this is there the other ground of consideration for the differential treatment besides those the prohibited by the article to the discrimination will be unconstitutional. Thus, the discrimination in favor of particular sex will be permissible if the classification the result of other consideration besides in fact that the person belong to the sex, physically or intellectual fitness for the some work. For instance, women may be considered to be better fitted for a job or a nurse, while they may have not be considered eligible for the employment of heavy industries like steel factories. Such a discrimination being based on ground of other than sex would be considered to be constitutional discrimination in the favor of men on the ground of sex alone the permissible Article 15 first of the Constitution, but the discrimination in favor of women is permissible view clause 3rd of Article 15 of the Constitution. But if a person is sought to be discriminated against simply because they belong to a particular community, race, or a sex, he can get the state action annulled through the court, while the racial discrimination still persists as a malignant growth upon the Western society. Speak of the volume Indian achievement that a possible victim of racial discrimination in India can obtain relief direct from the highest court of the land by mean of petition appropriate writ, and yet no such complaint has so far before the court. As already stated, its regard to the public places specified in clause 2, the protection available even against the discriminatory act by the individual clause by provide is so far places of public entertainment are concerned, no person shall be subjected to discrimination on the ground only the religion, race, caste, sex, place of birth of any of them, whether such discrimination is the result of any act of state or any other individual. Even well tanks, bathing ghats, road and places of public resort which are owned by private individual are subject to the prohibition provided they are maintained wholly and partly out of the state fund. They have been dedicated to use of general public. To have a prohibition against the discrimination, however, would not be preclude the state from making special provision for women and children, making special provision for the advancement of any socially and educationally backward classes of citizens from the scheduled caste and the scheduled tribe. These exceptions classes of women require the special protection, hence any legislation will be necessary for the making of a special provision of person. These classes would not be held to be unconstitutional. Similarly, though discrimination ground of caste provision by the clause 1 article, it would be permissible under the clause 4 of the state to the reserve seat for the member of backward classes or the scheduled caste or a tribe or a grant from a fee of concession in public educational institute. Article 15 clause 4 of the Constitution does not make any mandatory provision for the reservation and power of make reservation under this article. This is a discretionary and the no writ can be issued to effect reservation. Article 15.4 envisages the policy of compensatory and protective discrimination, but it should be a reasonable and consistent with the ultimate public interest, national interest and the interest of community or society as a whole. But a provision cannot be justifiably invoked in granting remission to the convicted person belonging to justifiably invoke the granting person belonging to a scheduled caste or scheduled tribes as it not be measured for their advancement. However, the benefit obtained permitted to the retained it held the SCST candidate selected to admission to course of the basis of merit. General candidate should not be treated a reserve candidate, and reservation for admission to the specialty, super specialty, not a graduation, and a doctoral course of medicine is permissible.